cases started being recorded from about, I mean, they've been known about, I guess, for much longer, but they started being paid attention to by the women's movement from the early 90s onwards. In fact, Geeta, who's here, I think, was involved in the very first investigation of the suicide of Nurjan Begum in Molvi Byzantium in the northern part of Bangladesh. Now, this incidence of fatwa violence and the sustained failure of the state to take any action was challenged in the courts. It started out being challenged through a suo motu order by a high court, an order being given of its own volition by a high court bench. And then a very over-enthusiastic judge holding not only that in that particular case had the relevant state agencies failed to act to protect the zone from violence, but going on to hold that all fatwas were wholly illegal and could not be issued. Unhelpful, we thought. And from ASK, we actually did also file an appeal asking for some modification of that order. Now, that case created a huge ruckus. There were mullahs on the streets, extremist groups on the streets demonstrating, there was police firing, there were lives lost, and there was an appeal filed, not by the government, but by two persons claiming to be muftis and persons learned in Islamic law, who said that their fundamental right to issue fatwas had been curtailed by this decision, and they went to the Supreme Court. And the Supreme Court quite happily took them in and accepted this petition. And for the next 10 years, we just played a waiting game of trying to make sure that in no circumstances did this case get heard, because we had a succession of absolutely appalling benches which would have leapt ahead and probably legislated fatwa into being if they'd been given the chance. So I think we used every possible excuse that is known to a lawyer, including personal incapacity, my lord, illness, my lord, senior counsel abroad, my lord, feeling slightly ill, my lord, feeling under the weather, my lord, it is about to storm, my lord, whatever we could use. And we kept it going, and we kept it alive for 10 years. And then finally, we had what we thought was our dream bench, which came into being, I think, was earlier last year or beginning of this year. And this was the bench which was headed by the Chief Justice. So I missed out, actually, probably the most important judgment I should have talked about, but it's too bad we do it later. The Fifth Amendment judgment, which had reinserted secularism in the Constitution. I missed it out because it's now been negated by this marvelous 15th Amendment, and I feel we shouldn't really spend any time reveling about it any longer. I also missed it out because this Chief Justice has so disgraced himself subsequently that I can't really bring myself to talk about his one big success. So you know the petty level at which I operate. But going back to this case, so it was before what we thought was our favorite Chief Justice ever and the best possible bench, and we went ahead. And again, everyone was very excited. 10 amicus, everyone's all said. We worked for months on submissions and so on. And the court came out again. This is new practice. A five-line order saying, upholding actually the judgment we had won earlier in the High Court, holding that yes, all forms of corporal punishment by bodies usurping judicial authority are clearly unconstitutional. That, I think, is such a no-brainer. Obviously, they had to uphold that part of it. And it was also hedged about with some nice language and a bit of international law and sea law and this, that. It was all done elegantly and well. But in the Supreme Court, they upheld that bit, and then they went on to hold that fatwas may be issued by persons who are properly educated in religious law on matters which relate to religious issues. Now, what on earth does that mean? What is a person properly educated in religious law? I think I can probably guarantee it is never going to be Gayatri, and it's certainly never going to be me, and it probably isn't going to be Azazan or his equivalent in Bangladesh. It is more likely to be someone who looks a bit like Heather Hussain. Secondly, what is properly educated? We have no explanation. And most importantly, what is a religious issue? And we had this debate, actually, at the very beginning in the Supreme Court, because they allowed in a whole bunch of, they had actually, I guess it was a fairly fair process, that any mufti who wants to come can come and make submissions. So we had a whole line of people landing up. And the first few who hadn't quite gauged the mood started out by saying, well, you see, if in a village a boy and a girl are together, something has to be done. And the only thing that can be done is through fatwa. But at that point, I have to say, this Chief Justice still had our sympathies because he glowered and shut down this line of argument very fast. But that is the point. That can, of course, be considered a religious issue, boy and girl holding hands and doing a little bit more than that in any village. And so how are we going to now say that issuing fatwas in those situations and issuing decrees saying they can't do that or they have to be ostracized, that is not possible? We don't know. So this is the kind of decision we're getting. I think I'm wrapping up in my next couple of minutes. There's a whole series of other kinds of interesting cases that have been achieved through public interest. What hasn't been achieved, and I think that's also important. I've talked, I think, about courts being used to sort of fire the gun for the government. I think we also have to be aware about runaway courts and judicial overreach, and I'm sure we'll hear more about this from Pakistan as well. And also about the magic wand PILs. I think this notion of judges that they somehow, when they're sitting on the bench, have got a peaked hat and a magic wand, and they can really solve every social ill simply by issuing these 5-line orders. So we have orders now: clean the rivers, end pollution, end child labor, end domestic servitude. You know, whatever you want, you pretty much get it. Nothing happens, but we have a lot of decent judgments. We go away feeling cheerful. The media has stories to write. The judge goes home thinking he's really achieved something or she's achieved something, but really nothing changes. What we also see is on the tough PILs, on the ones that aren't softly, nicey, you'll get written about in international journals and invited to conferences, on things that, for example, are about accommodation with important economic interests. For example, challenges to the practice of shipbreaking, or, for example, illegal occupations of flood flow zones by very powerful agencies like the National Garment Manufacturers Employees Association. The courts will not entertain those PILs. Or they'll entertain it, they'll do a little bit of feel good, and then they will throw it into the deep freeze or find some solution where there's no resolution and there's no real effectiveness. What we also see, the other limitations, I think, I talked about some of the politically sensitive cases, like Dr. Yunus's, for example. What we also see, what I think is very, very pernicious, and this is really the outcome of the politicization of the judiciary, is when judges start playing not the public interest, but the political interest in the equally. So, and this ties in, I think, with my first discussion about the war crimes tribunal, where we see situations where we are trying to get protections for individuals, for example, against abuse in police custody. And you cite what are well-established precedents of the courts about the manner of arrest without warrant, or the manner of taking someone into remand, and so on. And the court's response, and this is, I've not had this one time, but many times now in the last 2 years, is, well, I don't think we should be giving you those orders in this case, even though this case may be about a 65-year-old doddery Communist Party member who has been supporting the enforcement of a minimum wage of $40 a month for garment workers. We cannot give you orders in this case, because if you get this protection, and you know, we say that instead of taking your client into police remand for interrogation, you're allowed to have him interrogated at the jail gate or in hospital, then you see the war criminals will get that benefit. And even if you say, but my lord, that's not, you know, the international crimes tribunals across the road, that's going to look into that question. It's no. You see, we have to all consider the larger interest. And I think that's really the context that we're in. So it is this contradiction of still trying to maneuver our way through what is actually, unfortunately, pretty much a crumbling system. We have to just hope that it doesn't completely collapse around our ears while we're all still in those corridors. So I'm going to end. But before I end, I guess I should recall that some of you in this room, like me, were here in Colombia, actually, probably in another room, in 1995 when we were commemorating Bangladesh's 25th anniversary. And at that point I spoke, as I started today, also about General Irshad. He's kind of a bit of a constant in my life as an example of what clearly is impossible to achieve in terms of justice, and that there can never be too many rewards for someone who can be quite as wicked as wily as him. But at that point I had spoken of our hopes for ensuring that General Irshad, who was then in custody, would be brought to trial for his crimes, not only for gross corruption, but for illegal seizure of power and for the murder and torture of fellow citizens. But as you all know now, none of that came to pass. Not only is General Irshad, former dictator, ensconced as the leading ally of our very own quote-unquote daughter of democracy, but his legacy has been fully embraced by our ruling coalition, with only a few, definitely a few barely audible dissenting voices. And that's why I think I did start with talking about disillusionment and disenchantment, because I think that now that we are not living under a coalition government with fundamentalist forces who have, serious, who have so-called accused war criminals in their midst, the sense of betrayal by a party which really is the torchbearer of the liberation struggle is far, far worse. And the dreams that infused our post-war constitution of a full liberation from colonial occupation and militarism, of a plural society, of a democratic and secular nation, seem now to have been firmly laid to rest, or rather largely emptied of meaning and replaced by hollow rhetoric. So the term socialism has been reinserted in the Constitution, again by this extraordinary 15th Amendment, but it's been reinserted while crony capitalism reigns in practice and is the ruling order. Our leaders revel in their role as the torchbearers for women's empowerment, but as they go out of their way to deny the aspirations of women, whether it's women workers in the garment sector trying to hold on to this measly $40 monthly wage, or whether it's women in the rural sector, borrowers of institutions like Grameen Bank, who face attack and removal from their positions on the grounds that they are uneducated rural women and know no better. Similarly, and even more strangely, secularism is reinserted in our Constitution, again by the Magic Amendment, but alongside a parallel provision which retains Islam as the state religion, rendered, I think, somewhat meaningless by that juxtaposition. And of all the four pillars of the original Constitution of 72, secularism, socialism, democracy, perhaps the only one left intact, and the one we could have perhaps afforded to move a little bit beyond or interrogate further, is nationalism. In fact, Schriller's assertions of national sovereignty and territorial integrity and safeguarding the image of the nation are now the knee-jerk responses of the state to the mildest assertions of limited autonomy by, for example, indigenous peoples or Adivashis and those who speak in solidarity with them. And these are accompanied by reframing of the concept of national identity, not as plural, multiple, and diverse, but instead regressing, not 40 years, but I think 60 or more perhaps, the historians can tell us, to pre-partition politics, to a monolithic, hegemonic notion of the Bengali Muslim nation. And as a small code, I should also mention that some of the recent expressions by our leading ministers are not only do we have no indigenous peoples in Bangladesh, but we also recently, I'm told, have no sexual minorities. So I don't know how many millions of years that might be regressing. The process of adopting this new and yet regressive and repressive constitutional order, as well as its content, is clearly open to challenge on several grounds, including arbitrariness, including discrimination. And yet our conundrum now really is there's no forum for raising these questions. The court's pronouncements, as I've shown to some degree, are increasingly nothing but a dim echo of executive orders and interpretations. And once the potential check on executive excess, and as I said, to be fair, still capable of serving this function in cases with limited political cost, the court is increasingly perceived as being under executive control, whether directly or indirectly. With little scope for change now being affected in these matters through legal action, increasingly the only hope can be a broader political mobilization and a challenge being thrown by people to those who continue to abuse power and to misgovern and aid such processes. So I wanted to end with a song as I started, and I guess I'm doing this because I'm probably one of the